Hello Internet, and welcome to another episode of That's All I Have to Say About That Supreme Court Saturday. As always, I'm your host, Stephen Mackey. Now today we're talking about confessions. We're going to cover quite a few cases today because police like confessions, so over the years many people have confessed under strange and constitutionally questionable methods. So let's jump right in with 1895's Sparf vs. United States. Now this is honestly your classic late 19th century murder mystery case. Except one of the characters is named Sparf, a name that sounds like a typo on the birth certificate that the parents just kinda went with. One night on a voyage to Tahiti, Fitzgerald, the second mate, disappeared and was believed to be killed with his body thrown overboard. The ship's captain suspected Hansen and Sparf to be the murderers. Now because killing someone and throwing their body off a boat is a smart way of killing someone, remember that next time someone you teased in high school invites you to check out their new boat, there was very little evidence to prove anything had happened. Luckily, one of the two defendants confessed to the murder, which raised the question, if one of a pair of criminals confesses to murder, can that be used as evidence against the other? This led to a Supreme Court outcome that seemed unnecessarily complicated. Almost as though they had written the entire thing on one page and then realized they needed to drag it out to 2 or 3. Well, we already changed all the so's to henses and widened the margins, but we have to make this a little longer. Essentially, confessions made in the presence of the other accused without violence or coercion can be used as evidence against both, while confessions made alone could only be used as evidence against the confessing individual. Because, well, I'm not really sure why. Now this brings us to 1936's Brown vs. Mississippi, where Raymond Stewart, a white planter, was murdered in Kemper County, Mississippi, and his 3 black tenant farmers were arrested for his murder. Oh no, I can already tell this is not gonna be good. The leading evidence against him was that they were black people who knew him. Now the evidence did increase when all 3 of them confessed, but it later came out that was after brutal whippings and one of them was strung up by his neck. Now they were sentenced to be hanged, a decision that the Mississippi Supreme Court upheld, but don't worry because when it went to the Supreme Court, unanimously, that decision was overturned. A justice said, the transcript reads more like pages torn from some medieval account than a record made within the confines of a modern civilization. And that was coming from a time when modern civilization was the 1930s. When the Nazis were coming to power, we were emerging from an economic catastrophe and sexual harassment was rampant in the workplace. Oh no, it was modern society. Now this was viewed as violating the defendant's 14th Amendment due process rights, and subsequently they were free to go. Although fearing retrial, they did plead nolo contendere, or a plea in between guilty and not guilty. Basically meaning, maybe I didn't, landing them 6 months and 2.5 years and 7.5 years respectively. Now on to Chambers vs. Florida. An old man in Florida was murdered, so the police immediately stepped up and arrested 40 black people. Now after interrogation, it was narrowed down to 4 people who were shipped off to Miami for a week-long interrogation. This was a pre-Miranda rights interrogation, so the defendants not only didn't have access to a lawyer, but also weren't aware of their right to remain silent. Now after a week of random and sporadic interrogation, usually by upwards of 10 cops and additional community members, the 4 confessed to the crime and were sentenced to death. Their decision was not overturned at the appeals court on the condition that their confession was voluntary, although it was voluntary in the same way that slaves did volunteer work on farms. The Supreme Court did overturn this ruling, saying that the confessions were clearly compelled and were therefore inadmissible, marking one of the first times that the Supreme Court had accepted the contention that treatment short of physical violence still could result in the suppression of evidence, with that evidence being suppressed, the coerced confessions. This brings us to 1941's Lisenba vs. California. A darkly comical case which saw Major Raymond Lisenba go up on murder charges against his wife. Now the evidence against him was that he bought life insurance against his wife, and 3 months after that he bought several rattlesnakes in an unsuccessful attempt to murder his wife. Which, wow, did you get murder lessons from Wile E. Coyote? That said, 3 hours later she was found drowned, and investigators found that Major Lisenba had previous wives who had met similar fates. That said, when the police detained Lisenba, they held him for 2 days, beat him, and denied him legal counsel. So when he confessed, there was some wiggle room in interpretation. Although the court found that these illegal interrogation acts did not themselves constitute a due process violation, asserting that Lisenba had confessed on his own free will after being confronted with the testimony of an accomplice, not directly after the interrogation. So he was hung at San Quentin. Then there was 1949's case Ashcraft versus Tennessee, in which Ashcraft was accused of hiring John Ware, a black man, to kill his wife, and they both confessed. Now, while Ashcraft got your standard issue 36 hours of interrogation with only a 5-minute break, which, at that point, why even give a 5-minute break? John Ware claimed his confession was coerced because he feared mob violence. Their convictions were upheld by the state Supreme Court because apparently state Supreme Courts will uphold almost anything you put in front of them, but overturned by the federal Supreme Court. Interestingly enough, in this case, nobody said that the confessions were voluntary, and the circumstances were explained to the jury, leaving them to decide whether this was evidence or not. Because, when it comes to legal nuance, I really want those decisions to be left up to a jury of my peers. Now to the very important 1959 case of Spano versus New York. That is notable because it was the first time the Supreme Court transitioned from a case-by-case basis of interpreting whether confessions were voluntary towards the modern system of laying out specific rules for interrogations. Vincent Spano, an immigrant so Italian his blood type was marinara, got into a bar fight and then shot the other person after being injured. Spano, after contacting his friend on the police force Bruno, got a lawyer and then turned himself into law enforcement. While being interrogated, the police ignored his many requests to speak to his lawyer, threatened Bruno's employment to get a confession, and employed other strategies of getting a confession. After he confessed, the Supreme Court looked at the case and found that, first, it violated his 6th Amendment right to counsel, as well as violating his 14th Amendment right in 6 specific ways. This is where things really start moving fast. In 1964's Massiah versus United States, Massiah was appearing in court for a narcotics charge. On advice from his lawyer, he pled not guilty, but upon leaving the courthouse, he was invited by his friend, co-defendant, and total narc who was wearing a wire to discuss the case. Of course, he revealed all sorts of incriminating evidence against himself that was used in court as evidence against him. The question here was whether this violated his 6th Amendment right, creating the Massiah rule, which basically says that statements to be used as evidence need to be made with either an attorney present or the defendant knowing, voluntarily and intelligently waiving his right to counsel. Now, since he didn't know he was making statements on the record, he did not have an attorney in the back seat telling him to just remain silent and for the love of God, stop talking! The Supreme Court reviewed this case and ruled that the case needed to be retried without using the recordings as evidence. This brings us to the case you've all been waiting for, 1966's Miranda versus Arizona. Now this landmark piece of legislation is unsurprisingly more complicated than you would think. Much like a foreigner, when you finally think you've learned their name, they tell you their full name is Miranda v. State of Arizona, Westover v. United States, Vignera versus State of New York, State of California versus Stewart. Yes, it was actually all of those cases wrapped into one. Interestingly enough, in the case of Miranda v. State of Arizona, it was actually found that the state had not violated Miranda's rights. Good job, Arizona. Still doesn't make up for Sheriff Arpaio, though. This created Miranda rights, which are similar to Massiah rights, except that in this case it focuses on violations of the 5th Amendment, protection from self-incrimination, instead of violations of the 6th Amendment about needing a lawyer present. It basically ensures that the police remind you of your rights before they interrogate you, otherwise un-Mirandized statements cannot be used as evidence. You guys have seen Law & Order, you know what's up. Don't worry, these rights will be clarified in the following cases. Now to 1969's Frazier versus Cupp, where Frazier and his brother were picked up on suspicion of murder. The police lied to Frazier and told him that his cousin had confessed, leading him to confess, and since he had not requested a lawyer present, neither his Miranda nor his Massiah rights were being violated. Aw man, if there's one thing you should take away from this episode, just shut up and ask for a lawyer. Upon review of the case, it was found that the prosecution hadn't emphasized their confession in the case, using other evidence instead. It was also said by the court that the fact that the police had misrepresented the statements that the cousin had made is, while relevant, insufficient in our view to make this an otherwise voluntary confession inadmissible. So there you go. Don't trust the popo. Okay, this next one is full on creepy. 1977's Brewer vs. Williams. Williams was a former mental patient who had kidnapped a little girl in Des Moines, Iowa, and went on a road trip with her, killed her, and dumped her body. Williams turned himself in to Davenport, Iowa. During that time, he was properly Mirandized, but his lawyer was in Des Moines. He made an agreement with the police that he would not be interrogated by police until he could talk to his lawyer in Des Moines, but on the car trip over, their casual conversation, in one sentence, changed from how bad the weather was to how he should reveal the location of the body so she could get a proper Christian burial. You know, because that's how conversations work. Anyways, the legal question was, because there wasn't the requested lawyer present in the car, was any of this evidence admissible at all? Nope. The Supreme Court ruled that locating the body and the statements made in the car ride were inadmissible in court, although the body itself could be used as evidence. William got a retrial that didn't include statements made in the car ride as well as his assistance in locating the body, although he was still convicted of first-degree murder. This came up again in 1980's Rhode Island vs. Innis, when, after being arrested for armed robbery and read his rights and saying he wished to speak to a lawyer, upon transporting Innis to the courthouse, a conversation came up between the two cops talking about how there were a bunch of handicapped kids in the area, and if one of them found his loaded shotgun, they could be hurt. Come on guys, it couldn't just be kids, it had to be handicapped kids? That said, it worked, with Innis getting worried and helping the police find the weapon. In this case, though, the Supreme Court was not so sympathetic because of one crucial detail. In Williams' case, the state had already initiated formal judicial proceedings, and thus Williams was protected by the Massiah rights. In 1948's New York vs. Quarles, a New York police officer arrested a rape suspect who was thought to be armed in an open yet entirely empty grocery store, because apparently this was the finale to a cop movie and all the warehouses were already taken. Upon arrest, the officer found an empty holster and asked the man where the gun was, at which point, unmirandized, the guy pointed out the gun. During the trial, the man said since the gun was found as a direct result of his unmirandized advice, it was inadmissible as evidence. But in a surprisingly close 5-4 ruling, the court found that in situations where public safety is concerned, your Miranda rights might temporarily not apply. In 1986's Colorado vs. Connelly, Francis Connelly, after being read his rights and waiving his right to a lawyer, went into detail describing a murder he had committed. Soon after, the court deemed him not sound of mind and made him go to 6 months of therapy, at which point it was revealed that he believed God had told him to confess. I have to tell you, this might be the nicest schizophrenic command from God I've ever heard. Telling them to confess to murder instead of shooting up a mall? We need more of this guy's religion. The Colorado court exempted his confession as evidence because of his bouts with schizophrenia. But interestingly enough, the Supreme Court reversed that decision, saying that Miranda rights only protect people from government deception and withholding of rights, and not from mental problems. Yes, in this situation, if you have God on one shoulder and a lawyer on the other, I recommend you listen to the lawyer. This brings us to our final case, 2004's Missouri vs. Seibert, where the police had come up with a nifty little life hack for getting around people's Miranda rights. The trick was you don't Mirandize a suspect and get them to confess without knowing their rights. Give them a break, Mirandize them, remind them that they confessed, and then get them to confess again. This time while Mirandized. What a dick move! Anyways, this is exactly what happened to Seibert, whose unmirandized confession was not involved in the trial, but whose Mirandized confession was. The Supreme Court determined that Mirandizing someone mid-interrogation was just darn confusing to everyone involved and didn't help inform people being interrogated of their rights. Because, of course it's confusing. If mid-confession a guy tells me I have the right to remain silent and that everything I say can and will be used against me, I'd think he was the one hiding something. Because of this, the practice was ended. So that's where our current legal standing regarding confessions came from. This may surprise you, but I actually chose not to include quite a few of the less important cases in this subject. So if one of your favorite confessions didn't come up, feel free to mention it in the comments. Thank you, and that's all I have to say about that.